In initially handling Emma's client consultation, um, first I would try to introduce myself, be very kind and very open about how long I had been practicing or working in the law field. And I would try to make her comfortable, ask her if she wanted something to drink, like water, just to kind of gauge if she was comfortable coming in here into the office, because I'm sure for a lot of people it's intimidating. After that, I would then ask why she's here. I would try to give her personal anecdotes about my professional career to make her more comfortable. Then I would start to ask the injuries on her body, if they were a result of why she's coming in today. And then if she was open to speaking about the injuries, I would then ask what the paper in her hand was for. I would also ask why she's coming in, specifically the details of the event that led up to her injuries. I would get everything recorded and written down. And then we would also discuss what she wishes to bring from the event. Is she looking for a monetary settlement? Is she looking to go to litigation? Is she looking to be open to negotiations regarding the injuries sustained? I would also ask if she had any medical bills or had to take off work from the injuries sustained from the Hot Spoon restaurant. And handling settlement negotiation with opposing parties, I think, is probably one of the harder issues to try to resolve. First, I would see if both parties were interested in more of moving towards a resolution to the monetary issues at hand rather than the legal issues. If they all were in agreement to pursue monetary settlement, then I would explain how much my client was seeking. I would try to see if we were able to come to terms with numbers or payment plans, and then I would also ask if there's any insurance regarding the underlying injuries sustained, such as slip and fall insurance and insurance from the restaurant. After we determine the overall goal of the negotiations, I would then start to press upon lightly some of the legal issues regarding negotiation, such as, whose fault it is and who is owed the money. Reviewing the necessary steps to take with mediation. Generally 6 steps. The first step is planning, which means that the appointed mediator will confirm who all the parties will be, when they'll be present, and where they'll be present. The mediator will outline the mediation process and lay out the rules. For instance, what agreement we are to come to today. She will then give opening remarks, and each side has an opportunity to present its view without the disruption of another party. They also may take time to vent how they're feeling, and then at that point, the mediator will present solutions to the problems at hand. It's important for myself as Emma's representation to provide a lot of information, and I would ask a lot of questions from the other parties. During the time of which it's Emma's turn to talk, I would let her describe her events in her own words, and then additionally, once we are all able to ask questions of each other, I would bring up 3 particular topics, one of them being Hot Spoon's dog fence was not up to city ordinance. It was short, which then Emma's dog was able to jump over and injure Miss Potts. Additionally, I would ask the question of slip and fall insurance and the wet floor as a direct result of Emma's injury because Ms. Potts slipped on the wet floor. The third is I would bring up the issue of the no wet floor sign. For my research, I was able to find that for arbitration, you're able to seek a experienced arbitrator who has experience in your type of dispute. So, for example, for medical bills, you could hire a medical analyzer who can understand the injury sustained and the bills associated with both. Additionally, you can hire someone who's familiar with insurance and understanding who is liable for what. One of the benefits of arbitration is a term called splitting the baby, which in effect is an arbitrator may award both parties half of what they want so that the dispute could be settled in a fair manner. Reflecting upon the strategy between negotiation, mediation, and arbitration for both Mr. Jones and Mrs. Potts' lawsuit claim, I would specifically focus on the underlying issues of the restaurant's ability to pass city ordinance codes and Mr. Jones's liability regarding insurance for both Emma and Miss Potts as she was a customer in his restaurant, and the only reason her dog was able to jump over the fence was because his fence was not up to city ordinance standards, which could lead into other discussions regarding Mr. Jones's insurance being liable for Miss Potts's lawsuit regarding her slip and fall incident and the dog bite. Aside from those issues for Mrs. Potts, I would bring up the fact that the wet floor sign wasn't clearly stated, and Miss Potts could be held liable as she caused injury upon Emma, but I would try to focus more on the fact of Mr. Jones. I feel like that's a very valid dispute and a very valid argument to impose upon for legal reasons, especially with the city ordinance and his lack of a wet floor sign. Anticipating the strengths and weaknesses of my opponents, I think one of the strengths with Mrs. Potts' case is that under the theory of joint and several liability, joint and several liability, Mrs. Potts and Mr. Jones are equally liable for Emma, but I think for Mrs. Potts, she might, or her representation might be able to argue the fact that Emma and Mr. Jones are both liable because it was Emma's dog and Mr. Jones wasn't up to city ordinance. So I would try to impress upon insurance covering her injuries based on Mr. Jones's negligence. And I would also look up different types of slip and fall incidents. For example, when I was researching for our discussion board a few weeks ago, there were different types of slip and fall injuries. And aside from the fact that Emma's dog bit Mrs. Potts, her slip and fall, depending if it was a toe or heel injury, could be guarded as her being entitled to workers' compensation insurance if she does get injured. Additionally, for Emma, I would try to impress upon Mr. Jones's liability more, and I would try to see if we could come to a number for everyone to be agreeable to. Additionally, Emma had stated, I believe in the prompt, that she was okay if she didn't get $200,000. So knowing that my client is flexible with her settlement will help settlement negotiations all around. Obviously, I wouldn't start with a low number. I would start with the proposed amount, and then once I see a resolution coming everyone's way. For example, Ms. Potts is coming down 50% from her original proposed settlement, and Emma has as well, then we're able to cut down the settlement negotiations in half, and then hopefully see if Mr. Jones's insurance would cover at least 60% of the settlement.